The EU's General Data Protection Regulation, or GDPR, comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss the obligations of data processors. A crucial first step towards GDPR compliance is to identify your organisation's role in relation to personal data. You may be a controller. You may be one of two or more independent controllers in relation to the same personal data or data set. You may be one of two or more joint controllers. Or you could be a processor or sub-processor. While controllers have the main duties and obligations under GDPR, processors also have new and specific obligations, including an obligation to assist and support the controller's compliance procedures. Article 4 GDPR defines a processor as a natural or legal person, public authority, agency or other body that processes personal data on behalf of the controller. Article 4 defines processing in very broad terms, catching any operation or set of operations performed on personal data or sets of personal data, whether or not by automated means. This includes collection, storage, organizing, structuring, use, disclosure, combination, erasure, or destruction of personal data. The processor's obligations generally reflect the fact that they're processing personal data on behalf of a controller. Data controllers may only appoint data processors who provide sufficient guarantees in relation to technical and organizational measures to ensure that their processing meets the requirements of GDPR. Consequently, the first specific obligation of a processor is to process personal data in accordance with the controller's documented instructions. Just as a controller might outsource or delegate all or part of its processing operations to a data processor, so a data processor might contract some of its functions out to a sub-processor. The data processor's ability to use sub-processors is usually subject to a requirement for consent from the data controller. That prior consent may be specific or general. Where general consent has been given, the processor must inform the controller of any intended changes, including the addition or replacement of sub-processors, giving the controller a right to object. All data processing must, by virtue of Article 28 GDPR, be governed by a contract. Where a processor engages a sub-processor, the processor must ensure that there is, between itself and the sub-processor, a contract that carries through the processor's own obligations, meeting the minimum requirements of Article 28(3). The processor remains liable to the controller for any acts or omissions on the part of the sub-processor chosen by the processor to carry out certain functions. Among the key obligations of a data controller is the requirement to keep written records of processing activities. To support compliance by the data controller, processors must also maintain a record of all categories of processing activities. These records must include details of any controllers and any other processors, and of any relevant data protection officers involved in the processing activities. They must include the categories of processing, and they must give details of any transfers of data to third countries, that is, countries outside the European Union or the European Economic Area. and the records must include a general description of technical and organizational security measures. As with the controller's records, a processor's records must be provided to the regulator on request. Processors carry a significant degree of responsibility for data integrity and security. Processors must implement appropriate security measures, taking into account factors such as the sensitivity of the data and the risk to individuals associated with any security breach. The processor may have regard to the state of the art, to the costs of implementation, and to the nature of the processing. And measures might include steps such as encryption or pseudonymization of personal data. Crucially, the duty is ongoing and may involve regular testing of any security measures to identify any vulnerabilities or flaws and to allow them to be addressed. Processors must notify their relevant controller of any personal data breach without undue delay after becoming aware of it. This is intended to support and facilitate compliance with the data controller's obligation, which is to notify the regulator of a personal data breach no later than 72 hours after becoming aware of it. Like controllers, data processors must appoint data protection officers in certain circumstances, including where they are a public authority or body, where the data processing activities require or involve regular monitoring of data subjects on a large scale, or where the core activities of the processing involve large amounts of special category or sensitive personal data, or data relating to criminal convictions and offences. The data protection officer must have a degree of independence and is the point of contact for data subjects and for the regulator. Transfers of data outside the European Union or European Economic Area are prohibited unless appropriate safeguards are in place to secure and protect data subjects' rights. At national level, a third country may be the subject of an adequacy decision made by the EU Commission. Examples include the European Union, United States of America Privacy Shield arrangement. Where there is no adequacy decision in place, appropriate safeguards may be provided through means such as the use of model or standard clauses, binding corporate rules, or a legally binding instrument between public authorities. Processors may be subject to direct sanctions by the regulator. These range from access and audit rights to administrative orders and, as a last resort, fines of up to 4% of annual global turnover or 20 million euros, whichever is the higher. Processors may also be subject to direct action from data subjects. This can include claims for compensation under Article 82 made by any person who has suffered material or non-material damage, which includes distress, as a result of any GDPR infringement. Data subjects may also take direct action against a processor for any breach of lawful instructions given by the controller. It is possible that a processor may be liable both to the controller and data subjects for the same breach. Article 82, which deals with compensation, provides a mechanism for apportionment of responsibility between controller and processor, reflecting their relative degree of fault. Should you have any queries, or if you would like to seek advice on any of the issues discussed in this webcast, please contact our data law team. Details are on your screen at the moment. Thank you for listening to this GDPR webcast. Please join us for our other sessions on data controllers' obligations, data protection officers, data privacy impact assessments, GDPR contractual issues, and responding to personal data breach.